Hey out there, legal warriors, don't kill the messenger. Why do criminal cases take so long? And why is it that it's important that we let it take as long as it needs to get a good result? If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years. I'm putting out these videos to educate the public. So if you find it useful, please like and please subscribe. More people get to see it. More people get the help they need. Well, I'm going to be putting this video out on a Thursday, and I'm filming this one early. It's Tuesday, so I was walking around my office and said, hey, team, what topic would be really helpful for people that are calling our firm? And one of my younger employees told me, hey, how come court takes so long? Attorneys are always getting calls. Why is my pretrial set out this far? Or why is it the prosecutor hasn't responded? I want this over with. And it makes a lot of sense that that's how people feel. But that young staff person of mine said, Lance, it'd be really helpful if you could explain that to the public, again, about why is it cases take so long? And what is it that we can do about it? And number three, why pressing a case sometimes quickly can really diminish the chances of a good result. So let's talk about the criminal system. And what I'm going to talk about is a charged case. Now, uncharged cases, before I get into charged cases, are cases that, hey, you've been investigated, you've been arrested, or it's at the prosecutor's office. Now, how long a case takes to charge depends on the culture of the prosecutor's office, and their time is limited by the statute of limitations. Now, people make a mistake sometimes on a charged case. Once the case is going, the statute of limitations no longer applies. There's something called speedy trial that applies. But so on an uncharged case, the statute of limitations, which is 2 years for gross misdemeanors or 3 years for most felonies and no limit for some types of felonies, that applies when a case starts. Once a case is started, that's what I'm talking about now, a charged case, and now we have court dates, and we're saying, how come it's taking so long to finish up? Well, how does a court case start? It starts with an arraignment. Someone walks in and pleads not guilty, hopefully with their attorney. Now the court is going to set some court dates. And the court date that most people are going to have next is what we call a pretrial. A pretrial hearing is usually set within 30 or 60 days, and it is a hearing where sort of the attorneys are forced to think about, the prosecution and the defense are forced to think about, hey, this case exists, and we need to move it towards either motions, litigation, resolution, or trial. We need to move it towards some type of outcome. However, in the criminal system, what we always have to remember is that the prosecutor has an entire caseload of cases that are at different stages in the proceeding. So on that arraignment, we say not guilty, we get a pretrial. By the time we get to the first pretrial, the prosecutor probably hasn't thought much about the case. Why? Are they lazy or don't know what they're doing? No, they're buried under all the other cases they've already been dealing with when that case starts that we're talking about. If we approach a prosecutor too soon, asking for them to do something, hey, prosecutor, I know this case is only 3 weeks old, but I want you to dismiss it right now. They oftentimes will look at a defense attorney, why are you even talking to me now? This case is brand new. I haven't even had time to look at it. And by the way, the answer is no. And so when you approach a prosecutor about a case in a formal way, when it's at a time that they're unlikely to want to or be able to have that executive function, that decision-making ability to even talk about the case, you're likely to get a no. And once they write no down in that file, well, when you're talking to them 3 months later, didn't I already tell you no? Right. So you have to sort of be careful because we're dealing with humans in this type of negotiation. So why does a case take so long? One reason is strategy that you want to talk to the person making the decision at a time they're going to be open to that conversation. And many times they're not open to conversation about new cases because they're buried under the cases that are 6 months or 9 months or 12 months old. And in that situation, why do they care about those older ones? Because now at some point that judge is going to say no more continuances, and they're going to force everybody to a trial. Well, a prosecutor typically doesn't mind going to a trial. They mind going to 10 or 12 trials because they can only do one at a time. So that's a little bit of the psychology of how come sometimes a case is going to take longer, that we can't negotiate it at a first pretrial. What's another reason why a case takes a long time? Sometimes it's just the court calendaring, right? It can be really annoying. We show up for that pretrial date. We're going to ask for a continuance, and the court says our next date is 70 days out, right? I can think of one court in King County, who shall remain nameless to protect the innocent, that you can't really get a court date quickly sometimes when we want a court date. And that's, again, based upon sort of staffing and how many people are in the court. So how many people have court cases in the court? So what should you expect? Well, if your attorney is telling you, hey, we're going to get a continuance, expect 30, 40, 45 days. But if the court's really backed up, it might be much longer. It might be closer to 60 or 70 days for the new court date. And then it just drags on. And the hard part for the client or the person that's accused, and it's a part that sometimes us people in the system that are defense attorneys or even prosecutors forget about, is it's a lot of mental anguish to be accused of a crime and have that case held open held open above your head for that period of time, because not knowing what's going to happen causes a lot of anxiety. And it does for us too as defense attorneys, but obviously it probably causes a lot more anxiety for the person charged with the crime, because number one, the consequences could fall on them directly, and number two, they have little ability to actually control the outcome. They can help the attorney do things that the attorney needs to help influence the outcome, but they can't negotiate or do things directly with the prosecutor themselves. So that's another reason why the case takes a while. What's another thing you have to remember so you don't kill the messenger? Well, some prosecutors nowadays, they're so overwhelmed they hide, okay? Especially when we have courts that have Zoom court. There are some courts out there, again, I'll protect the innocent, courts out there where all of these pretrial hearings are done by Zoom. They don't have even in-person as an option. Still here in 2025, there's some courts that say all pretrials are going to be by Zoom. In that case, there's no way us attorneys can do it the old-fashioned way. We can't walk into court and say, hey, now you need to talk to me about this, and talk to them in the courtroom. In that type of situation, what could happen is we send an email, we do a phone call, and if they don't feel like responding to the defense, what don't they do? They don't respond. And then it gets continued again and again and again, unless the attorney takes a different approach, and sometimes we're forced to do this. The attorney might force it towards a trial to put some pressure on the prosecutor to make them to respond. But remember, when we put something towards a trial, if it ends up at a trial, we then lose control of the outcome, right? Remember, do you watch a lot of YouTube trials? Do you watch a lot of things on TV? A defendant, I'm sorry to say, even though we're supposedly presumed innocent, that's a lie, in my opinion. Although we're presumed innocent, that defendant at a trial is not sitting in the not guilty chair. They're sitting in the guilty chair, right? And jurors have a really hard time, especially today when everybody hates everybody, to find a way to let someone go unless we can really turn the case on its end and make it a case against the government or against someone else as the bad person, not the defendant. So if we try to pressure the prosecutor to make them speed up, that does put the client at additional risk. So it's always a balancing, right? It's balancing for moving a case forward. It's like we want to get that outcome for the client that they need with as little risk and pain as possible. But to get that outcome, we put the client through additional pain and anxiety because it's taking longer. And the reason why, as a rule, the criminal defense industry charges flat rates and not hourly rates is because time helps cases. Time helps outcomes typically. And if someone was being charged by the hour, they were paying more money. As the case took longer, they would not trust their attorney. They would think they were continuing the case for additional financial gain. They wouldn't let the attorney continue the case, and the results would suffer. Believe me, it would be much better for the criminal defense industry if they were charging by the hour, but it's not worth the mental anguish it creates between client and attorney that need to trust each other because we're fighting for somebody's life. This is not fighting over money. This is not fighting over employment. This is fighting over freedom. And so we cannot afford to set up a situation where there isn't trust between the client and the attorney. At least that's my opinion of why the industry works that way. No one's told me that, but it's pretty obvious from being in it for 30 plus years. So cases can take a long time. People always ask me, how long does an average case take? I say a city misdemeanor, city prosecutor misdemeanor, 3 to 6 months. I say a state prosecution misdemeanor, 6 to 12 months. I say a felony, 1 to 2 years. I say a serious felony, 2 or more years, typically for many cases to get resolved or pushed on towards a trial. What can you do to speed that up? Follow your attorney's instructions, right? Get stuff done right away. Be reasonable in saying, yes, I will do whatever you need to do to help me get this case resolved. And let your attorney know what you actually need. Don't live in fantasy land that I'm worried what's going to be on my background check. If you're in court, it's already on a background check. Nothing is invisible. Big data controls everything, right? So what we're trying to do is we're trying to protect someone's criminal record. We're trying to limit risk. We're trying to get the case done as soon as possible. But remember, don't kill the messenger. We are trying to help you. We need you to have patience in trying to understand that there are strategy reasons that things happen how they do, and sometimes it's beyond our control. That prosecutor may say they're going to look at our case and they never get to it. What are we going to do? Flip them the bird and tell them to go to you know where? Well, we don't want to make them mad because now they're going to try to get you, right? So we want to have that understanding that we are going to try to get the result as smartly and hopefully as quietly as possible to get that outcome you need with little pain and little risk. So I hope you found this helpful. If so, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you have a criminal matter in Washington State, feel free to reach out to my firm. We've been doing this more than 25 years. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.